We've brought together 50 bankruptcy attorneys, one from every state.
Can I keep my car?
What about my house?
Can I rebuild my ACE, my 341 meeting?
Whether you're drowning in debt or just treading water, our panel is here to handle the questions that keep you up at night. Real answers from lawyers who do this every day. If you want to be connected with a lawyer in your state for a free consultation, see the link in the description.
The question on everyone's mind, do I have to give up everything I own? On the buzzer, Matthew Frey from Michigan. What are the rules on keeping your stuff?
So under Chapter 7, the law is going to allow you to keep certain amounts of property. We call these exemptions, okay? Many people are very confused on this, but the easiest example I like to give my clients is it's not numbers and categories. It's not one house, it's not one car, one pair of shoes, one set of socks. It's numbers and categories for dollar signs. So we're talking TV show Jeopardy, home equity for X, vehicle equity for Y, personal property for Z. Depending on your state, you're going to have some different rules. We have federal exemptions, which allow you to keep lots of different property, but maybe a little bit light on home equity. We have state exemptions in many states where it might be a little higher on the home equity, but you might not be able to preserve any kind of cash assets. So the point is, when we talk to clients, we remind them the bankruptcy code is not trying to take the shirt off your back, literally. They're allowing you a certain amount of base level assets to move forward once you get your fresh start. At the same time, there is a limit. We can't have $1 million paid off house, for example, in most jurisdictions. I mean, there might be a way, depending on how long you've owned it and who's on the deed with you. But in most cases, there's a cap. And if you're beyond that cap, under Chapter 7, that's going to allow the trustee to investigate the asset, potentially seize it, liquidate it, pay you your protected or exempt amount, and use the balance to pay back your debts. Okay? In many cases, if that does happen, a lot of times you can work out a deal with the trustee because they don't want to spend a lot of time and effort trying to seize and sell things. It's a lot of work to sell a house. You know, they got to put a for sale sign up, hire a realtor, have showings. You know, they don't know if they'll get the magic number or not. The realtor wants to be compensated. Then they got to deal with you, who's still there. So many times a deal can be struck under Chapter 7 to maintain possession of your assets. If it's an asset like a tax refund or money in the bank, probably not much of a deal there because it's just hard cold numbers. It's not a lot of money or a lot of effort, I would say, to just write a check. So when it comes to deciding, is bankruptcy right for me under Chapter 7, that's the big question is what assets do you have that are at risk? I find very few debtors want to risk their assets. And you need to talk to someone who knows what the exemption strategies are, who understands how the trustee is going to look at the exemptions and the dollar amounts that you put on there on your schedules, and what resources they're going to look at to see what they think your property is going to be worth. A lot of trustees have preferred resources, and if your attorney knows what those are, they'll be able to counsel you up front as to here's the value we need to lift or here's what we need to go with. You can take a shot in the dark, and a lot of people do, unfortunately, and they come up on the wrong side because, they feel like I just want to make the number work. Well, that's not always the best strategy, and a lot of times it can backfire on you because the trustees do investigate property values. It's one of the most thoroughly investigated portions that we see here. They may file objections to your exemptions, and all of that's a lot of work. It's a horrendous amount of work for someone who's representing themselves because they're not going to understand what's going on. But for an attorney, it's also a lot of work. That's why you want to just start up front with, here's what you can keep, here's where we're at. There may be some wiggle room. As I tell people, we factor in costs of sale and things like that. We can do some math and figure out how someone's going to look at that. But, again, when you're going back to thinking about, should I file Chapter 7, the question not only is, do I have a lot of debt, but do I have assets that I might lose? And what is the ramification to me when I make that decision? Because once you file that case, as I tell everybody that I go with here or goes with my office, it's a one-way bus ticket for Chapter 7. You get on that Greyhound bus, you are in it, win, lose, or draw. The bankruptcy estate is opened, and if you don't have your stuff lined up, you are going to lose it. Okay, you don't have the right to quit, to back out, to say no thanks, never mind. That's a Chapter 13 you can dismiss voluntarily. Chapter 7, you got to get it right when you file the case.
Thanks for watching. If you want to be connected with a lawyer in your state for a free consultation, see the link in the description. And if you have a question, leave it in the comments.